Showcasing your religious faith is nothing uncommon these days, but what happens when people or organizations use public property for religious displays? Our legal correspondent, David Lesch, tackles this topic now as we begin our legal segment. And David, good to have you.
How are you? Well, now that the Halloween displays are taken down, it's time to put up some of the displays for Christmas, and I'm sure in the next couple of weeks we're going to see many of these displays, and sometimes we see them on public property, which brings the perennial debate, the separation of what would be considered church and state, and whether or not you should be allowed to put religious displays on public library grounds.
Right. Now, years ago, this wasn't even a problem. Now it seems as though it seems to be a growing and a heightened look at this.
Well, you know, it always goes back to the Establishment Clause of the First Amendment. The Establishment Clause reads that Congress shall make no law respecting an establishment of religion. And it's clear. You know, the government is not supposed to be promoting one particular religion. That's the way it is. And scholars have read into that means there should be a separation of church and state, but there never is a specific reference to separation of church and state in the Constitution. So we go back to just that Establishment Clause itself. And the problem with the clause in some respects is that the Founding Fathers had a very strong belief in religion, and it's intertwined in everything we do. I mean, Congress and the government acts in a very schizophrenic way when it comes to this particular area, because, you know, before Congress even is in session, many times they have a prayer. Go to any courthouse, and a lot of times on the sides of the courthouse, what do you see? You see the Ten Commandments. So these are religious objects. So it's a fine line as to what is considered to be establishing a religion and what might be considered to be just promoting your own history. So recently there have been cases that have come up before the Supreme Court. One particular case is McCreary. That particular case, you had certain states that were promoting, it was Rhode Island and Pennsylvania, were giving monies to counties that had teachers that were putting forth certain religious views in certain classes. And they basically said, if you teach a certain way, we're going to give you an extra bonus at the end of the year.
Right.
And the states, in many respects, were promoting those classes that put forth a different bent on religion. Well, obviously some parents sued under 14 U.S.C. Title 1983, and this court struck that down. Basically stating that there's a test that should be followed, and it was considered to be the Lemon test. This was back in 2005. And it says that's a three-part test which weighs the religious nature of the action and asks, really, does it foster an excessive government entanglement with religion? Which is really, you know, a convoluted way of saying, are you pushing forth religion as opposed to history? If you say that you're going to put certain displays on your property or put it on the side of a courthouse and say, well, this is the history of our country. Add to it the Magna Carta. Put on different types of displays that show where we came from as a country.
Okay.
That's okay.
But not, right, okay.
But if you're going to be putting forth certain religious views, not based it on the history of our country, but based it on God or your own religious bent, well, that's not going to be okay. But do you see how difficult this is in terms of a constitutional law?
But we know there have been cases where mangers have been on public property, government property, as a matter of fact, and a strong fight and a push to actually, you know, take away the manger at Christmas time off of the property. And in many cases, in that particular case, that was won.
That's right. Well, you know, the states say, well, the nativity scene, that's our history. That's the history of our state. You know, we've always had this, and that's our history. Well, wait, hold on a second. That's not necessarily history. That's more often than that's more often than not religion. The nativity scene is not going to be considered something that you can say is history. That promotes religion. Well, what about, you know, the Ten Commandments? Well, the Ten Commandments that's history, isn't it? I mean, that's the history of our law. Our law is based in fact, in sometime into the Ten Commandments. You could talk some about the Bill of Rights. Maybe some of the Ten Commandments are incorporated there. Maybe you could say that was used as a way for the founders to create the Bill of Rights. That's history. So it's a very fine line. And you know, and that's what makes, you know, in terms of the constitutional law series that I'm doing so interesting, is that there's never really an answer, as opposed to some of the other areas that I discuss.
Because there's a lot of gray areas.
There's a lot of gray, and that's the point of constitutional law. There's no clear answer. You know, I can come in, I can come on set and I could talk about certain immigration issues or landlord-tenant issues, and I can tell you, this is the law, this is the way it is. You can't do that with many of the constitutional law issues that I discuss. There's no clear answer. So I guess if I had to give a guideline in terms of what can or cannot be done with respect to religious artifacts on public property, as long as it's for some type of historical purpose, and you couple it with other types of, you know, other types of documentation that support the notion that it's for history. If you're going to put the Ten Commandments there, then put a little scene of the Magna Carta there, right, or other things there. If you're going to put a nativity scene, then you better put the Ten Commandments or other things there as well. Show that it's religion. Basically, if it's been there for a long time on the side of a courthouse or whatever, it's not going to have to be taken down because it is history. Right. But if it's a new courthouse or if it's a new public building and you're putting that on the side,
there's a good chance you're going to face this kind. What kind of numbers are we seeing in court? Are we seeing a lot of this going?
Well,
in
you know,
the
every time the holiday season comes on and there's a public display on, you know, on the public library or wherever it is, there's always going to be somebody who's going to bring a court challenge, and again it comes before the court, and this lemon test is going to be applied. And back in, I think it was in 2005, it was split. It was a 5-4. It was a very close decision because it's split within in the courthouse too. You know, and Scalia made a very interesting comment that, you know, that in some respects, you know, the justices in the majority are really striking a blow at religion. You know, it depends on what side of the street that you come down on, and you know, we're a country that does have "In God We Trust" on our pennies and on our nickels.
And in the courthouse.
In the courthouse, you know, well, there are people who don't believe in God. Is God a religion itself, or is God a supreme being? And how do you define that for purposes of constitutional law and the Establishment Clause? That's why I enjoy the constitutional law series, because it gives me a chance to kind of debate, yet walk off saying, well, there's no real answer on it, you know, and there's never going to be an answer as to what's considered to be religious and non-religious. But it makes for just some interesting debate, I think.
So there's a lot of gray area. Really, it doesn't really. I mean, so when it comes to bottom line, the verdicts, it falls out on both sides, or
well. I guess the bottom line is, if you're going to be debating the Establishment Clause, as long as you can somehow show that there's a historical bent to it and your state was founded on this particular display, you know, Ten Commandments or nativity scene, or this has been in there for the last 200 years in your state, you can put it places to say, well, this is how we were created, and it's been on the property for so long. But if you're building a new public building and you don't have a history of having these types of displays on other buildings, it's going to be very hard for you to make an argument that you're doing this just because it's the history of your state. There's going to be others who feel that you're promoting a religion, you're establishing some type of religious bent, and therefore it's going to be unconstitutional and you're going to have to take it down.
So the holidays are coming, so we can look forward to seeing some more drama?
Absolutely, drama. That's what constitutional law is about.
Okay, what else do we have forthcoming in the future?
Well, you know, we're going to have a professor coming on debating this particular subject on today's verdict, which is going to be coming up in a couple of weeks on my show, which is going to be great. And we're also going to be talking about some mandatory testing, HIV testing, government employees, those types of things. That's going to be coming up. So we have some good shows coming up in the next couple of weeks on today's verdict. And of course, I'm always going to be here every week continuing the constitutional law series. I have an interesting question that I wanted to discuss, the right of women to breastfeed in public. I think that's been a constitutional law, or breastfeeding at work. That's a constitutional law issue that we're going to be discussing. Also, the right to smoke marijuana is always an issue that seems to be debated back and forth, you know, whether it's medical marijuana or not, constitutional law issue. So these are issues that are going to be discussed, and by the spring we'll move into a different area.
Seems like the freer we get, the more the courts begin to get tied up with.
That's exactly true.
Debating.
Exactly true.
All righty. Well, David Lesch, good to have you.